Can I just please welcome everybody and thank you very much for joining us to a series of talks which we at Goldsmith Chambers are providing by webinar in relation to three areas of law that we have some excellent practitioners in: civil, family and immigration law. And I hope you will find them all of benefit and interest. And can I recommend and suggest that those who are perhaps practicing more than one area should think about also sticking around and or joining further of these talks and these seminars in the future, because I think they will be hopefully of assistance for practitioners, even if you just practice in one area, but certainly if you practice in a number of areas. The aim in relation to these series of webinars is to deal with some of the legal issues which are thrown up by the situation, the crisis that we face in relation to Covid-19, and to give some general training in the areas of law which we think people are likely to be looking to and in the future in terms of looking for remedies for situations that they face with difficulty at the moment. We think that there will be in the future quite an area of work to be considered for practitioners in this field to look at further down the line. And so what the series of talks are aimed at is hoping to assist in relation to the remedies which might be available for people who have been suffering in ways for which there may be a legal avenue of redress. And we hope you find them all extremely useful. So the first of these talks is in the area of civil law, and I'm delighted to welcome Ollie Newman and Ian Cain, both of whom I am absolutely confident will be of great interest and hopefully of benefit to you to go through some of the legal issues surrounding matters of limitation and relief from sanctions. Thank you very much indeed.
Thank you, Tony. And just by way of a couple of bits of housekeeping, this talk is being recorded, and the only people that can be seen on the recording are myself, Ian, and Tony. But there is the chat function and the Q&A function. Please do use those if you have a difficulty or if there are any questions. We've got quite a lot to go through in a relatively limited period of time. But what we'll do is, as we get towards the end, Ian's going to have a look through any questions that anybody may have, and we'll try and deal with a few of those towards the end of the talk. And there is also going to be, coming out after this, a note that covers everything that we're going to be talking about, but also a couple of other bits and pieces of detail that won't be in this talk. So if there's anything that you feel you've missed or that hasn't been covered in detail, that should, I hope, be in the accompanying note. But first we're going to start on looking at limitation. So a common issue in this day and age, you've got a limitation date approaching, but your client you're struggling to take instructions from, you've got an issue with an expert who can't come back to you, hasn't done their report, or some other problem that means that you're not actually quite ready, but you're up against a limitation date. And so, Ian, is there any help from any of the legislative or rule changes out there?
Well, sadly, we're in the position where the Coronavirus Act 2020 hasn't offered any further guidance as to exactly what we're supposed to do in regards to the limitation period. As you correctly say, Ollie, it's not just an issue for solicitors and indeed your clients as well. The courts themselves are currently facing big issues when it comes to limitation, because there's an awful lot of work. There is a backlog which is forming within the court system. Indeed, I was informed only last week by a district judge that courts are very reluctant to list anything that would usually be heard by a deputy district judge at the moment. Now, of course, it's not just been the Coronavirus Act 2020 which has come into effect. There have also been the amendments to the civil procedure rules. And if you haven't already looked, if you go onto the Goldsmith Chambers website, in the news feed, you will see a note which has been very kindly put together, again by Oliver Newman, in regards to those changes to civil procedure rules. Sadly, we are still in the position where claimants are expected to comply with the relevant limitation periods. question is, what can then be done to overcome these inevitable problems? And Ollie has put his mind to this and has come up with 4 possible approaches. So perhaps you'd like to take us through the first one, Ollie.
So the first approach you can take is a limitation amnesty. And this is the approach that the PI claimants and defendants have largely agreed and have taken. And the first point really is to say that such an agreement has to be prospective. You can't agree an amnesty after the deadline has passed, which means you've got to identify potential issues early. Though quite an attractive approach, really, there are some danger areas to limitation amnesties. Firstly, the terms need to be clear, they need to be in writing. In particular, the extension period needs to be clear and precise. If you send a letter saying, well, I'd like a extension for 2 months, the question is, does that run from when you ask for the extension, or does it run from when the other side replies saying, yes, I grant you the extension? So you are much, much better to have agreements that specify a date and a time than to specify a time period. Because if there is later an argument about whether you've met that extended limitation period, that's obviously going to be problematic and you don't want to lose it. Make sure that the amnesty is agreed with all potential defendants. You've got to be careful about this, because if you don't do that and you leave out a defendant, then you may run out of time in relation to them, leaving your client potentially without a remedy, even if you succeeded against others, or if the people you've identified as defendants turn out not to be appropriate. Lastly, if the agreement, and they quite commonly do, allows the defendant to revoke the amnesty upon giving notice, you need to think quite carefully about what that notice period needs to be and how it's to be communicated. Firstly, in terms of the notice period, well, if you do get written to and said, actually, we're revoking that amnesty, you're going to need enough time to turn the case around and be ready to issue it. So make sure you've got at least a couple of weeks in order to give yourself the time to do that. And equally, make sure it's clear how it's going to be communicated, that revocation. You don't want it to go by post to a closed office and discover that it's been revocated and you had no idea. So specifying an email address, but an obvious point there is that if you are specifying an email address to a particular person, make sure that when that limitation amnesty date starts to close on you, that is somebody who is going to be in the office or available to answer that email, because you don't want it going to a furloughed member of staff. So limitation amnesties potentially very helpful, but they do have their limitations. In particular, I should say that if the other side don't agree it, then you've obviously got to do something else. So, Ian, is there something that the courts can do?
Well, indeed. The second approach is, if you really are pushed for time, you haven't had the option to speak to the other side and agree that amnesty, you can simply go ahead and issue the claim and then apply for an extension of time in which to serve the claim form itself. Important to note, though, that this is far riskier, especially at the moment, given the backlog that has already begun to build up within the county court. And the courts, because they are already struggling for time to fit in present caseload, will struggle to fit in an application as well for that extension of time. Defendants themselves can apply to set aside an order granting the extension of time, meaning that potentially you are just building up more litigation within the claim itself. And the court frequently themselves will grant those applications to set aside. And in particular, the court will want to see that there is a good reason for that inability to serve the claim form within the specified time. So it's an approach which does require some care and consideration before embarking on it. Ollie, is there anything else that can be done?
Well, let's say that you are in a position to issue, but you don't necessarily want to make an application for court. Well, there's again the approach that you can reach an agreement to extend time for service of the claim form. Many of the same considerations apply to a limitation amnesty, but again, you've got to ensure the agreement is prospective. Don't try and reach it as you are approaching the deadline for service of the claim form. Make sure that agreement is in writing and make sure it's clearly drafted. I'm just going to pause here to mention the fact that although perhaps getting these agreements is not necessarily the easiest thing, you may say, well, the other side aren't going to agree to this. We'll come to some of the points a bit later in relation to what the practice directions say. But the reality is the courts are under enormous strain. Any party that is unreasonably refusing such agreements that then necessitates applications to the court is very likely to face cost consequences to that. I think it is very unlikely that courts are going to be sympathetic by attempts to game the system to get some kind of advantage by refusing to agree reasonable requests either for a limitation amnesty or to extend time for service of the claim form. But even if that is the case, is there anything else, last gasp approach for the court?
Indeed, it's effectively continuing on from the point that you've already made, but we have put this into a fourth category on its own, in that you can go ahead and serve the claim form and then make the application for an extension of time, service of the particulars of claim after you've served that claim form. The application itself has to be within the standard 4 months as granted by the civil procedure rules. And the advantage of this approach over some of the other approaches that we've mentioned, again, I would say is behind reaching an agreement between the two parties, that when the court comes to consider any prejudice, the only prejudice that the court will consider is that resulting from the grant of the extension of time itself, either of the two parties, making it more likely that the court is willing to grant such an application. It also makes it incredibly difficult for defendants, therefore, to oppose these applications, even if the court isn't willing to oppose it of its own volition. So now that we've gone through those 4 different approaches that can be taken, what are ultimately the key points that we should be taking away from this?
So firstly, as we said, the Coronavirus Act and the practice direction doesn't come to assist you here. Limitation periods still apply. There hasn't been any softening of that to acknowledge the difficulties that people face. But what you've got to do is, as soon as it becomes apparent that you're facing difficulties, proactively consider how to deal with them. If you know a deadline is approaching, you can look at agreements, you can look at applications to the court, as long as you do it prospectively. If you miss these deadlines, trying to sort that out becomes far more difficult, far more painful, and far more likely to result in disaster. I would suggest that extension by agreement should always be the first approach. It's frankly cheaper, it's simpler, or should be simpler, and given the current pressure on the courts, I've said unreasonable refusal that necessitates an application is likely to have adverse cost consequences for the party making that refusal. But as I've said, ensure any extension by agreement is prospective, in writing, and I know I've said it several times, but it's really important, be precise about your dates to avoid arguments down the road. So that's limitation. What happens when it goes wrong? You've got past the limitation issues, but you've got a situation where your witness statement needs to be served, but you can't get hold of the client, or you've got expert evidence that's late, or you've got disclosure documents that you've got to do, any of those things that can be affected by the current situation. Well, there's yet to be any reported cases dealing with relief from sanctions in the context of COVID-19. But having said that, we can obtain some guidance from the new Practice Direction 51ZA, and there are now a trickle of cases coming through, mostly on adjournments and applications to extend time, but from those we can pull some useful principles as to how the courts are going to deal with such applications. So Ian, what does Practice Direction 51ZA say?
Well, fortunately, as you can see up on the screen, it says, insofar as compatible with the proper administration of justice, the court will take into account the impact of the COVID-19 pandemic when considering applications for the extension of time for compliance with directions, the adjournment of hearings and applications for relief from sanctions. So as you can see there, this is the first time in which we've had pure acknowledgement from the court that there is going to be issues caused by the COVID-19 pandemic, and that the courts are to take those issues into consideration when it comes to considering any applications. But Ollie, what exactly does this mean in practice?
Indeed, because of course the impact of and consideration are pretty wide terms. Well, the first case, and the citations for these will be in the full note, is Heineken supply chain, where Deputy High Court Judge Alexander QC was facing questions about how a trial was to proceed, and what the timetabling for witness evidence and expert evidence and so forth should be. Now, he's sort of looked at the different sides to it. He acknowledged the pandemic had required individuals to reorganise aspects of their personal and professional lives, and that preparing documents and evidence had been made harder by what was happening. But, and this is a point that I'll come back to because I think it is really important, he criticised the lack of detail in the evidence provided to him as the problems caused by the disruption. And he went on to note that it referred fairly explicitly to the efforts of doctors and nurses and so far, but stated that it was not unreasonable to expect that lawyers concerned with keeping cases on track may need on occasion to push a little harder to enable that to be achieved. Now, in this case, he did agree to push back one of the dates for compliance in terms of service of evidence, but they kept the trial. So it's a first indication of a little bit of how the courts are going to balance this. But there's more detail set out in Municipo di Marina and BHP Group, a case that came after Heineken. His Honour Judge Iri QC referred back to Heineken, but he set out 9 principles to guide the courts when dealing. I mean, he was considering an application to extend time for compliance with directions or adjournment with hearings. Again, we've dealt with some of the guidance and so forth in relation to the adjournment of hearings and how they'll proceed in the note on remote hearings and the note in relation to practice directions. But of course, all of this is useful and is going to be relevant to trying to look at permission for failing to meet deadlines. What he said is that existing deadlines should be kept to if achievable, and any extension should be for as short as reasonably practicable. So their reflection of the reference in the practice direction to the administration of justice. The court's not going to just allow deadlines and so forth to blow past. They're going to try and keep things on track as much as possible. So that legal professionals will be expected to use technology to overcome problems with remote working, and that legal professionals will be expected to go further than might previously been expected, particularly where a failure to meet a deadline will jeopardise a trial date. So there's a few points to unpack in there. Firstly, that a reference purely to the fact that it's difficult to contact clients, or my files are in the office or the like, it is unlikely in and of itself to be faced with vast sympathy. The courts will be expecting remote access of documents for solicitors to be using Zoom or WhatsApp or Teams or any of the other systems out there to communicate. And there is also a bit of an emphasis that there will be an expectation to problem solve proactively, not just sort of say it can't be done and therefore. But it's also important to note that it's referring particularly to the fact that expert witnesses will be expected to do likewise. Now, that's interesting for 2 reasons. Firstly, because it's placing the same sorts of burdens on expert witnesses as it is to legal professionals. But what's also notable is, of course, what he's cutting out of that is lay witnesses. There isn't an expectation that all lay witnesses will have access to laptops, will be able to use the various technologies that it would be expected that a legal professional will be able to use. Notes that the court should be willing to accept evidence that's less polished and focused than usual if necessary to meet a deadline. So what perhaps we come down to there is that the court's not going to have a lot of sympathy if you haven't filed your expert report, because you are asking for a sort of second or third draft of it because you want to make a particular point or something like that. The courts are going to have to and are willing to accept the fact that evidence may not be quite as precise or as rounded as it might be in usual circumstances where you're under the cosh to meet a deadline. Notes on the other side, I suppose, weighing it a different way, the court should take account of the realities of the situation and avoid requiring compliance with deadlines that are not achievable even with proper effort. So though the court is placing legal professionals under a certain amount of pressure, there is an acknowledgement that there's only so much that's possible. And connected to that, again, I think this is very important, notes the court must have regard to the consequences of movement restrictions and working from home, including IT setups and other responsibilities such as childcare and supporting vulnerable persons. Some acknowledgement there that, of course, the people working on these cases, everyone working on these cases, may well have different responsibilities or different calls on their time than might be usual. Even if you are working full time, if you've got children at home, that's going to limit your availability, the amount of time you've got. So I think that's quite a useful line potentially to counterbalance the sort of above and beyond points being made, but to acknowledge that the court is going to have to take account of the fact that IT doesn't always work. There are other pressures on people's times at the moment. A last point of that is states an extension of time that will require loss of a trial date, granted less readily than one that does not. And of course, that's really a common principle and applies to applications for relief from sanctions as well. So pulling these two cases together with a practice direction, what are the sort of key takeaways here? Well, firstly, referring a simple reference to the fact that this wasn't possible due to COVID-19 alone is unlikely to act as a magic bullet in applications for relief from sanctions. The guidance is the court has to take account of the difficulties, but that has to be balanced against the administration of justice. COVID-19 is not going to be treated as an explanation as to why nothing has been done. But a reference to COVID-19 backed by detailed explanation of the problems caused is likely to satisfy the good reason test. And detailed explanation is an important point here. The court's not going to accept the fact that you couldn't have a face-to-face meeting with your client as the be-all and end-all explanation of why something couldn't be done. But if you're saying, look, we've tried to use Zoom, but they are not technologically capable, they don't have Wi-Fi, they don't have a tablet or a system to do that on, we say, we've done what we can, but the expert needs to visit the location. We've looked at trying to do a stream or a video or something to assist, but it's just not suitable, isn't sufficient for whatever reason. Those sorts of more detailed explanations are very likely to satisfy the good reason test. A clear timeline may well be of assistance and may well be of importance here, because the courts, I think, are far more likely to be sympathetic to problems caused by disruption at the start of the lockdown. So if you're talking about a deadline that came around the 23rd of March for a witness statement or something like that, and you've got a situation where you're having to very suddenly move to remote working, having difficulties accessing files in the office, you're having to move towards seeing clients remotely, the court is likely to have a lot of sympathy with issues caused by that sort of level of disruption at that point. The corollary or the other side of that is that as this drags on, the court is less likely to accept those sorts of explanations and those sorts of issues. If you're 3, 4, 5 weeks in, the court will, I suspect, lean more heavily on the identified points that lawyers should be using technology and so forth to solve some of these problems. So it's that timeline may well impact upon how sympathetic the court is depending on the issue you're facing. Should also say that issues about availability of staff due to furlough are likely to only go so far. Again, I come back to the sort of administration of justice point. The courts aren't going to accept, I suspect, that having made a decision to furlough all your staff, that there were insufficient people to comply with professional obligations. I don't imagine that will go down terribly well, because the courts are likely to say, well, you had these series of professional obligations and you had to meet them. But of course, the other side is saying that we reduced our staff to a degree, and of who was remaining, people had childcare issues, people had technology problems, and that's what's really caused the problem. That is far more likely to receive a sympathetic hearing. So it may simply be more about how you word it and where you put the emphasis, but it's a way of how you present it. Simply saying we didn't have enough staff is unlikely to go very far. And lastly, just a note that if there was an issue due to the health of a witness or a solicitor or an expert witness or somebody like that, it is going to be more important than ever to make sure that you're seeking such evidence as you need in good time. At the moment, it can be even more than usual, very difficult to obtain letters or medical records from the NHS or medical staff. So if your application is really very reliant on something like that, make sure that you're asking for those things in good time, because if you don't, you're likely to end up in a situation where you haven't got sufficient information. All right, well, that takes us through the topics that we were planning to cover. As I say, we have done, there is a practice note that deals with a couple of these issues in a little bit more detail. Ian, I know you were having a look just to see if there's any questions or comments from anybody that we haven't covered or they'd like to deal with now.
Indeed. So just as a reminder to everyone, you can send your questions to us using the Q&A box at the bottom of your screen, or by sending us a chat message directly using that box again at the bottom of your screen. Before we move on to those questions, there was an email that we received in saying that we are due to exchange witness statements with the solicitors, the other side, in a case that we have in which the limitation or the period, for the exchange of those statements would be next week. Unfortunately, we've received an out-of-office email response from that solicitor's firm saying that that member of staff has been furloughed. What can we do if that date for the exchange of statements is going to be missed? So, Ollie, what are your first thoughts on that?
I suppose it's always going to be very difficult with some of that when you've got furlough on the other side. You've not quite up against the sort of court date in quite the same way, but you're then starting to, I suppose, come into to a certain degree issues of frustration and the like. I think if you've got a contractual date, then you've really got to progress on that basis. I suppose beyond that, if you have a situation where you can't exchange and then the other side have breached their contract, then you're going to have to look at what the remedies might be and what the costs are in terms of that your client's accruing if it's simply not possible to exchange in line with that.
The next question that we've had in is, what do you do if the other side have asked for an extension but haven't provided a proper reason as to why that extension is required?
I think you've still got to, the other side should be giving a proper reason. I think it's a slightly tricky area because, as I said, I think the courts are going to be quite sympathetic to people saying, well, we asked for an extension, they didn't give us one, so we had to make an application to the court. But I don't see any reason why you couldn't ask for reasons for that. As I say, it's the interest of justice point really that to run is to say, well, look, we're not going to be unreasonable about this, but as the courts themselves have said, the court system, the legal system still has to roll on. Simply saying we want an extension isn't really sufficient. We need to have some explanation, even if it's fairly thin, for that, because there is a balance here between progressing cases and dealing with the problems being thrown up. So I think that's, I don't think it's unreasonable to ask to have an explanation for that. And I think as long as you're not unreasonable, if you're given something, then you probably agree it. But equally, if you're simply refused an answer as to why they want it, I think you probably cover yourself cost-wise if it comes down later. Just to note, this is being recorded, and we will place the recording, the slides, and the note that will be sent out on our website after this. So those things will be covered.
So I think we've got time just for a couple more questions. Of course, if we don't have enough time to get to your questions, please do get in contact with Ben Cresley and Alice Martin on the telephone number and email address which has been provided on that slide in front of you. So should clients come to remote hearings for relief or direction hearings, or should it only be counsel who are in attendance for those hearings? Well, Ollie, I would imagine that the answer is it depends on what the court says and depends on the type of hearing. Would you agree?
Yes, I think it depends on what your grounds are. If you've got a situation where you're trying to rely on, well, I suppose it depends a bit, but if you've got a situation where you're relying on something specific about the client, you may need the client there. If your issue is because of difficulties on the solicitor side, then probably not. One thing I'd note is that just in terms of remote hearings and evidence and the like, that because a lot of this may well be starting to be dealt with on paper, because it's remote, because you may have difficulties with client attendance, and because of the way that the remote hearings are tending to work, it is more important than ever that you are putting detail in the witness statements in support of applications. If they're dealt with on paper, as a lot of things are being dealt with, there won't be an opportunity to add to that. And if it's being dealt with at a hearing, it may limit the amount and limit the opportunities for counsel to add or to sort of add to anything that you've said. So making sure that your arguments and your evidence is in writing is more important than ever.
And I think we'll take this one, unfortunately, as the last question. But does the extension asked have to be COVID related, or does the practice direction cover the extension as a general rule in all circumstances?
So I don't want to confuse issues here. And the practice direction allows, the new rule practice direction allows extension to 56 days compared to the original 28. That does not have to be as such COVID related, it just has to be agreed. That doesn't control anything in relation, that it doesn't say if you've got an issue that's subject to something else, you can't rely on that extension to 56 days. The point being, I think the point being made is that the court are explicitly stating that COVID should be and can be considered when looking at these extensions, and giving, I suppose, reassurance in some ways that the court will explicitly look at the problems thrown up by COVID when and if it comes to applications for extension of time and inevitably for relief of sanctions and the like. So there doesn't, in terms of that 56 days from the practice direction, that doesn't have to be COVID related. Equally, you don't have to be citing COVID in relation to look for limitation amnesties or other extensions. But obviously it's going to be persuasive and easier if you can, but it's not limited to scenarios where COVID has caused a problem.
Thank you very much, Ollie. Unfortunately, I think we're going to need to leave it there with the questions for a moment. Of course, you will have the opportunity to ask further questions in the other sessions that we have upcoming. Ollie, I believe that tomorrow is the family team giving a session on divorce. Is that correct?
Yes, the family team tomorrow are starting their series and a sort of introduction to matrimonial proceedings with divorce and through. On Thursday, we've got a talk in relation to commercial property and the impact that COVID and some of the practice direction changes impact on that. And on Friday, the immigration team will be on to speak as well. So as I say, I'm sorry that we've not got through everybody's questions. There will be a note out that will deal with what we've said in some more detail, and we will upload this talk and the slides. And for any specific questions in relation to cases, we've obviously put up Ben Cressy's email address. But if there is anything specific in terms of advice on cases that would be of assistance, please do let us know, and we'll see what we can do to help.
Hopefully you all would have seen the schedule, which is up on Eventbrite, for all of the talks that we have coming up beyond this week, as Ollie has already gone through. But also, if you or your firm would particularly benefit from a specific presentation or webinar on any issues that you specifically have, or indeed if there's any training that you would like to be given to your firm, our staff are being furloughed, again, please do get in contact with Ben Cresley on the email address and telephone number, and we will do everything that we can to assist you.